Hi there, I'm Jenna Leyton Jones, the Vice President of Legislation for San Diego SHRM, and today I'm bringing you your quarterly employment law update. Let's start by taking a look at some California legislation. Governor Brown has signed into law Assembly Bill 987, which provides that an employer may not retaliate or otherwise discriminate against a person for requesting accommodation of his or her disability or religious beliefs, regardless of whether the accommodation request is granted. This bill was drafted in response to a recent judicial decision, Rope v. Autoclore Systems of Washington, wherein a California appellate court held that an employee's request for reasonable accommodation is not protected activity under the Fair Employment and Housing Act. This new law abrogates the Rope decision and makes requests for reasonable accommodation protected activity such that an employer may be held liable for retaliation if it takes an adverse employment action against an employee because of such request. Governor Brown has also signed into law Assembly Bill 560, which confirms that all protections, rights, and remedies available under state law are available to all individuals in the state who have applied for employment or are currently employed, regardless of immigration status. The bill further provides that for purposes of enforcing state labor, employment, civil rights, and employee housing laws, a person's immigration status is irrelevant to the issue of liability, and discovery into a person's immigration status is prohibited unless the person seeking to make the inquiry has shown by clear and convincing evidence that the inquiry is necessary to comply with federal immigration law. Governor Brown has also signed into law Assembly Bill 1506, a bill that limits employers' potential exposure to lawsuits brought pursuant to the Private Attorneys General Act, or PAGA, for certain technical violations of the Labor Code. Under existing law, employers must provide their employees with specific information regarding their wages, including but not limited to the inclusive dates of the period for which the employee is paid and the name and address of the legal entity that is the employer. Existing law does not afford employers any opportunity to cure violations of these requirements before an employee is permitted to bring a lawsuit under the PAGA. This bill provides an employer with the right to cure a violation of the requirement that it provide its employees with the inclusive dates of the pay period and the name and address of the legal entity that is the employer before an employee may bring a civil action under the PAGA. The bill limits employers' right to cure to once in a 12-month period. Governor Brown has vetoed Assembly Bill 465, a bill that would have prohibited employers from requiring employees to sign an arbitration agreement as a condition of employment. Governor Brown has also vetoed Senate Bill 406, which would have significantly expanded the California Family Rights Act. Now let's switch gears and take a look at some of the recent judicial decisions that may affect your business. In Sacob v. Luxottica Retail North America, the Ninth Circuit Court of Appeals held that a waiver of the plaintiff's Representative Private Attorneys General Act, or PAGA claim, could not be enforced. Plaintiff Shukri Sacob filed a wage and hour class action lawsuit against his former employer, defendant Luxottica Retail North America. Sacob later amended his complaint to add a representative claim pursuant to the PAGA, which allows employees to step into the shoes of the California Attorney General and bring representative actions for alleged labor code violations. The U.S. District Court for the Southern District of California granted Luxottica's motion to compel arbitration based on 2 arbitration agreements Sacob entered into during his employment. The arbitration agreements expressly precluded Sacob from pursuing class, collective, or representative claims, whether in court or in arbitration. Pursuant to Luxottica's motion, Sacob's class and representative PAGA claims were dismissed. Shortly after the district court entered its order on Luxottica's motion, the California Supreme Court issued its ruling in Niskanian v. CLS Transportation, Los Angeles, holding that waivers of representative PAGA claims are contrary to California public policy and are thus unenforceable. Sacob appealed the district court's order, arguing that his representative PAGA claim could not be waived. On appeal, Luxottica argued that the Niskanian rule conflicts with the Federal Arbitration Act's objectives and is therefore preempted. The Ninth Circuit ultimately agreed with Sacob, holding that the Niskanian rule is not preempted by the FAA and that the waiver of Sacob's representative PAGA claims was therefore unenforceable. According to the FAA, a written arbitration agreement is to be enforced according to its terms except on grounds that exist at law or in equity for the revocation of any contract. The FAA's so-called savings clause permits arbitration agreements to be invalidated by generally applicable contract defenses such as fraud, duress, or unconscionability, but not by defenses that apply only to arbitration. If a generally applicable state rule interferes with the FAA's objectives, it is preempted by federal law. In its ruling, the Ninth Circuit explained that the FAA does not preempt the Iskanian rule for two reasons. First, the Iskanian rule bars the waiver of representative PAGA claims in any kind of contract, whether the contract concerns arbitration or not. Second, the Iskanian rule does not conflict with the FAA's purposes. More specifically, because the Iskanian rule does not prohibit outright the arbitration of certain claims, but rather prohibits only the waiver of representative PAGA claims, the rule does not interfere with the FAA's goal of overcoming judicial hostility to arbitration. Moreover, the Iskanian rule does not prevent the parties from selecting the procedures they want applied in arbitration, and therefore does not interfere with arbitration. The Ninth Circuit reasoned as follows. A PAGA action is an action brought on the state's behalf. It is not a mechanism for resolving the claims of other employees. In contrast, a class action is designed to adjudicate the claims of absent class members. Therefore, principles of due process mandate that class members' rights be protected by requiring special and formal procedures to resolve those claims. Because representative PAGA claims do not require any special procedures, prohibiting waiver of such claims does not diminish parties' freedom to select the arbitration procedures that best suit their needs. What does all of this mean for employers? Employers have long been familiar with California courts' distaste for arbitration. The Iskanian decision is merely one in a long line of cases, making it increasingly difficult for employers to enforce their contractual agreements to arbitrate. However, in the absence of binding authority from the Ninth Circuit as to the validity of the Iskanian rule, numerous federal district courts in California have enforced representative PAGA waivers. Now that the Ninth Circuit has weighed in, employers face yet another unwelcome hurdle to the enforcement of PAGA waivers. Unless and until SACOB or some other case makes its way to the U.S. Supreme Court, California employers will be precluded from enforcing PAGA waivers in either state or federal court. In Sanchez v. Valencia Holding Company, the California Supreme Court held that the arbitration clause at issue was procedurally unconscionable but not substantively unconscionable. Accordingly, the court reversed the lower court's order denying a motion to compel arbitration. In Sanchez, the plaintiff filed a class action lawsuit against defendant Valencia Holding Company, alleging that Valencia had violated the Consumers Legal Remedies Act. Sanchez alleged that Valencia misrepresented the condition of a pre-owned automobile he had purchased from the company and also improperly charged him various fees relating to the transaction. Pursuant to an arbitration clause contained within the sale contract, Valencia moved to compel the dispute to arbitration. Valencia also sought dismissal of Sanchez's class claims pursuant to a class action waiver appearing in the arbitration clause. The trial court denied the motion, holding that the class action waiver was unenforceable because the CLRA expressly provides for class action litigation and declares that the right to a class action is unwaivable. Valencia appealed. The Court of Appeal affirmed on other grounds, concluding that the arbitration clause contained elements of procedural and substantive unconscionability. In reversing the Court of Appeal's ruling, the California Supreme Court first discussed the standard for proving unconscionability. Importantly, the court held that the traditional descriptions of substantive unconscionability, contract terms that are, quote, overly harsh, so one-sided as to shock the conscience, unduly oppressive, unreasonably favorable, or unfairly one-sided, all mean the same thing. That is, substantive unconscionability requires a substantial degree of unfairness beyond a simple old-fashioned bad bargain. Applying this principle to the Sanchez case, the court concluded that although the arbitration clause was procedurally unconscionable because the sales contract was a contract of adhesion, it was not substantively unconscionable for reasons not relevant to the employment disputes. The California Supreme Court also upheld the class action waiver pursuant to AT&T Mobility versus Concepcion. In Concepcion, the U.S. Supreme Court held that a state rule invalidating class waivers interferes with the fundamental attributes of arbitration and is therefore preempted by federal law. The California Supreme Court concluded that Concepcion preempted the trial court's invalidation of the class action waiver. As such, the court reversed the trial court's denial of the motion to compel arbitration. Though decided in the context of consumer arbitration agreement, the Sanchez case provides helpful guidance to employers seeking to enforce arbitration agreements. Sanchez makes it clear that the many formulations of substantive unconscionability in fact represent the same standard. Thus, plaintiff employees will likely be unable to argue that any particular formulation requires a greater or lesser evidentiary showing. Moreover, plaintiff employees will likely have greater difficulty avoiding a contractual agreement to arbitrate by simply arguing that such agreement was unfavorable to them. Rather, employees will be required to demonstrate that they were subjected to something substantially more than a bad bargain. Finally, in Higgins-Williams v. Sutter Medical Foundation, a California Court of Appeal held that a plaintiff's inability to work for a particular supervisor was not a disability under the Fair Employment and Housing Act. Plaintiff Michelin Higgins-Williams worked as a clinical assistant in the Shared Services Department for defendant Sutter Medical Foundation. Higgins-Williams had an immediate supervisor and a regional manager. She sought treatment for work-related stress and anxiety. Her doctor diagnosed her as having adjustment disorder with anxiety. He reported her disabling condition as stress when dealing with human resources and her manager. Sutter granted Higgins-Williams' request for leave. Thereafter, Higgins-Williams' doctor extended her leave several times and stated that she would only be able to return to work if she were permanently transferred to another department and worked for different supervisors. Sutter terminated Higgins-Williams' employment. Higgins-Williams sued for disability discrimination, failure to engage in the interactive process, retaliation, wrongful termination, and discrimination. The trial court found that Higgins-Williams was not disabled within the meaning of the FEHA. Higgins-Williams appealed. The Court of Appeal agreed, holding that an employee's inability to work under a particular supervisor because of anxiety and stress related to the supervisor's standard oversight of the employee's job performance does not constitute a disability under the FEHA. The court reasoned that being unable to work for a specific supervisor is not a limit on a major life activity. Accordingly, an employer need not accommodate an employee's request to work under a different supervisor merely because the employee is anxious or stressed while working for a particular supervisor. The cases I just mentioned are just a sampling of recent judicial decisions that affect California's employers. For more information on these and other hot legal topics, check out San Diego SHRM's newsletter, The Resource, at www.sdshrm.org. Additionally, I invite all of you to join San Diego SHRM's Legislation Committee, where you'll have an opportunity to impact the lawmaking process and the legislative decisions that affect you and your business. For more information about this exciting opportunity, please email me at jleyton@petitcone.com. That's all for this quarter's legal update. Thanks for tuning in.